Call the meeting to order. It's 5:34 p.m., June 11th. Call to order, roll call.
Yes. Brian Rutherford is absent. Daniel Ryan,
Present.
AJ Lang,
Present.
Andrew Belt is absent. Rosemary Mail,
Present.
and Tim Orrick. Thank you. We do have a quorum.
Thank you. We are going to hold off on election of officers until we have a full board, if that's all right with everybody. Because I'm going to try to railroad Andrew.
Sorry, need to nominate you.
Well, I'm going to flip the darn. All right. All righty. Planning and legal staff, you're going to provide us with training, I do believe.
Mr. Chairman, Jay Leipzig, I was just going to give just a quick introduction to this topic, and I appreciate the chance to present this to you. This is something we've talked about doing for the last year, so I apologize it's taken so long to get this in front of you. We wanted to make sure we had, first of all, we have a meeting. There were some changes with legal staff as well. And so we're excited to present this to you. And I think this is a great format, and it's a new format. But I want to introduce some new folks. We have Chris Grunwald is our Deputy Director of Legal Services. That's here this evening. Chris just joined us, 2 months ago, Chris? It's been that long? Not quite. Okay. Very glad to have him. Came a long distance with the city of Olathe, just right up the street. And then we also have Ryan here. Ryan Haga has been, I think many of you have seen Ryan before, the legal team. So between Ryan and Chris, then Sean as well, we've got a pretty good presentation for you this evening. Unfortunately, I'm going to have to back out, and I'm going to the meeting over in DeSoto. So I will leave and go to the other meeting over there. But with that, I'll turn it over to, I know who's starting. Is it Chris? Are you starting? Okay. Thanks, you guys.
Okay. Good evening, commissioners or board members, probably more appropriate there. I'll preemptively apologize. A little bit of a scratchy throat, and I've got a cough drop in. Just this thing I got from my kids. I got the upgraded version. It's just not quite gone. With that, as you heard, I'm a newer member of the legal team, so looking forward to supporting between Ryan and I, giving support to all those zoning boards, Board of Zoning Appeals, Planning Commission, planning staff. I like geeking out on that stuff, so that's a good opportunity. So we've worked together with planning staff. We're going to tag team this to break it up a little bit. So I'm going to do the first part of it. We'll hand it over to Sean. I'll just close it out. I would say this, if you have questions along the way, I go ahead and jump in with questions, so don't feel like you need to hold them to the end. We're just trying to set the framework of a reminder about your role, your position, and the basic types of cases you get. And you can see here in the agenda, just a little bit about your process and just some other considerations are really for all boards, and questions at the end also in case you need them. All right, a quick reminder probably for you folks. I know several of you have been on the board for a while, but there are some state statutes about planning. There are general state statutes about planning, and there are some specific to counties and some specific to Johnson County. In this case, Johnson County is required to have a Board of Zoning Appeals. So when the Board of County Commissioners adopted the zoning regulations that we use as the organizing regulations for making decisions on the cases you hear, as well as the other types of cases that go through planning, that whole set of zoning regulations includes the section that applies to you guys. So it creates a Board of Zoning Appeals. It establishes how many members you have. And I guess the other things I put on this slide are, again, there's more to your role in terms of just you are here to hear cases. The purpose behind that is to provide the community an opportunity to have a voice in planning and development, which is really important. So we appreciate your service, and it's very important to our community and to the board. And so it's important for, we want to make sure we express our appreciation for that. The state statute and the zoning regulations work together to establish what is the stuff that this board hears. And you really have two flavors of cases or applications that come before you. You have variances, and I'll go forward here a slide and backwards, and you have administrative appeals. So I'll touch on each of those in turn. So variances are by far the more common thing that come before you. So a Board of Zoning Appeals is to allow an opportunity for a special situation, and we'll go over the factors in detail. Sean's going to handle that part. There are elements that have to be met in order to be granted relief, but the purpose of a variance is to give relief to a property owner from the zoning regulations in certain situations. There are only certain types of things that are appropriate for a variance. They're listed here on the slide. What we're talking about is building height and setbacks, lot size and lot dimensions. So it's not just anything. I'm going to emphasize that last bullet point. It's not permitted uses. So to take perhaps the absurd example, somebody wants a brick factory in residential, and you're like, that's not a permitted use. Maybe I can get a variance. No. So the types of things that this board is hearing and the variances are created is for the more specific lot and property specific conditions. And you see that list of 4 items right there. The second flavor of case that you might hear as a Board of Zoning Appeals is less common, but it is available. This board is available to hear and decide appeals from other administrative decisions. So we have the county appoints, has as part of planning staff a zoning administrator. That zoning administrator can make official decisions. Those decisions might be interpretations of the regulations and how they apply to a property. In that situation, it could be the property owner wants an appeal of that decision. The first stop, rather than going immediately to district court, the first stop would be this board for an interpretation of whether or not the zoning administrator's decision, the planning staff's administrative decision is appropriate or not. So this is an opportunity for a property owner to come before the board, present their information, and they may ask the board to reverse the decision or to modify it. You can see underneath the first description there that those are your options as the board. You can reverse the decision. You could affirm it in total or in part. You can make modifications to it. That's highlighted there in relation to modifications where there might be appropriate conditions that the board seeks to add. They're seeking relief from something, but you're allowed within the scope of your authority under the zoning regulations to include some additional conditions. Maybe you have a timing aspect or some other aspect about the property where they get relief from something, and you want to make sure they've followed all their processes. You can attach that condition. Yes, you can go forward and not follow that part of the regulations, but you might need to do something else. Tim?
What would be an example? Is that limited to those setbacks? Whatnot?
This is not, great question. So
Vision that would be subject.
I'll tell you that. So the question, just in case, so that everybody could hear it, was what are examples of the sorts of conditions, and does it relate back to? I'll go back a slide. Does it relate back to the list of things that are in the variance list? It does not relate limited just to that list. And in fact, if you're seeking a variance, you need to go under an application for a variance and deal with it there. So it's listed in the regulations just this broadly. So the regulations themselves don't give the examples. The best example I can come up with in terms of this discussion is that if there was a request for relief from an interpretation about whether particular, say, building materials or other things that might be an interpretation of what qualifies as that. what I would say in that example is if the Board of Zoning Appeals decided to go with the property owner in that case and say, you know, we're going to interpret that as a Category 1 type material instead of Category 2 based on the information presented so that it would qualify under the design regulations for something. Maybe that interpretation might require, I'm going to require you to submit a sample of that material so that it's on file with the planning staff and we know exactly what material we're dealing with and the building inspectors can verify that's the type of material. That's an attempt to give you an example where it's, again, it's very case specific and it's very specific to the property and the project at issue. It might be something where the board, again, wants to put something to make sure both the property owner and the staff know exactly what's got to be done by when or what's being interpreted. Any other questions on that?
Who serves as the zoning administrator?
Good question. This is Sean Penley, planning staff. The zoning administrator would either be the director or the deputy director. So either Jay Leipzig or myself. We usually making those decisions. And to this point, usually these types of appeals of administrative decisions were probably something that was what would have been an administrative type decision initially, or it's usually not an appeal of an actual board case usually, although we have had one of those that did get to the BZA. Usually it's a decision made on an administrative application and we just interpreted something and maybe made a ruling and told a developer or property owner, here's what is required. And if they would disagree with that interpretation, then they could appeal it in writing with an appeal to the administrator. And then that would then be scheduled for hearing with BZA.
One of the most important things that the board is doing here when they're hearing the property owner making a request for relief, whether it's a variance or administrative appeal, is hold a public hearing. And so this is the opportunity to create a record. The property owner gets to make their case and explain their reasons for it. And the planning staff will also be able to explain their interpretation and their recommendation. As you've heard before, variance cases might come in with a staff recommendation of approval. So these are opportunities for all of the information to get in front of the board and the board to open a public hearing, allow anybody who is interested in presenting relevant information. It's not an opportunity to talk about anything. It's about this case that's in front of you and an opportunity to put statements of folks. It's not a rigorous court of law standard here. It says the word evidence, but the intent here is to provide information in the record that will allow you as the board to make a good decision. And because in the case of certain decisions, those might go on further to the Board of County Commissioners. And it could be that there's an unhappy applicant that is deciding to sue to overturn a decision of the Board of Zoning Appeals or Board of County Commissioners. And in those situations, there'll be a court reviewing it. And so that's why the public hearing is very important to both accomplish in an orderly way. There are bylaws of the board that establish the mechanics of how a hearing is presented to make sure everything is orderly and everyone gets a chance to present their information. But again, emphasis there, it's creating that record that is very important potentially for future action either by the Board of County Commissioners or district court if there ends up being a dispute about it. So when does the Board of County Commissioners get decisions? The slide is attempting to summarize that situation. So if the Board of Zoning Appeals ends up deciding to, let's say, grant a variance, so that's allowing a variance away from what the regulations state and allowing an opportunity for the property owner to proceed anyway. Or if the Board of Zoning Appeals were to decide an administrative appeal against staff's recommendation and rule in favor of the property owner, those decisions are going up to the Board of County Commissioners. There is a clock. The Board of County Commissioners does need to take action. If they do nothing, then the Board of Zoning Appeals decision becomes final. If the Board of County Commissioners is interested in taking a look at this in more detail, then what they need to do is they need to, within that 2-week period, set a public hearing. They'll hold another public hearing. I would say that does not mean that the public hearing that happened in front of the board was unnecessary or a waste of time. All of that information is certainly helpful to staff and the Board of County Commissioners as it moves on through. but they're required by the regulations to hold another public hearing if they choose to review the Board of Zoning Appeals decision to either grant the variance or affirm an administrative appeal. This is where I hand it off to Sean. We're going to talk a little bit about the types of cases and the types of factors for variances, and then I'll come back at the end.
All right, thanks, Chris. Good evening, Sean Pendley, planning staff. As Chris started this presentation, what he's going through the kind of the procedural and the requirements and the duties of the board, and he'll finish up, as he mentioned, with some other procedural matters and considerations. But what I'll try to go through in the middle here is the types of cases, just a general overview of the different types of applications you may receive and consider. And you will maybe recall these board members may recall some of these cases. To start with, we wanted to give a general overview of the types of cases. So I thought it was helpful to look back the last 5 years as an example for how many types of cases and what types of cases the BZA would consider. And usually it's averages about 1 or 2 cases a year. Sometimes we've had some years where there's none. I will say these are usually a variance or a case that goes to the Board of Zoning Appeals should be very rare, ideally, because there are usually other recourses or other methods or procedures to go through to appeal decisions, because usually they're associated with an actual zoning decision that was required to go to the zoning board and Board of County Commissioners. But if they're the type of criteria that we're looking at and what I'll get into in detail, it goes before the Board of Zoning Appeals. So usually most cases, as you know, are variances. And as Chris said, a variance should be a dimensional requirement, not use variances. We'll get into that. But this just shows you kind of an overview. Again, the last 5 years, we have usually 1 or 2 cases a year, and they're most always a variance of usually a building height or building setback requirement. That's what usually most of these cases are. So we'll go through a couple of examples here just to discuss what is considered. We also wanted to go over our staff reports. This is something that staff really tries to provide a good record, the beginning of the public record, to provide the board with that background on the case, what is going on with existing conditions, what is the property owner proposing or requesting, and then we get into the zoning summary. We want to make sure we give the board the details for what is required by the regulations and what is the applicant asking for in terms of that request for an exception or a variance. Then we also provide in the report what the BZA's authority and the criteria is that needs to be considered. There is that mandatory criteria that I'll go through in a minute. And then staff has to provide our analysis to provide the board what we feel is the appropriate recommendation, because that is really essential to give the board our recommendation so that you can provide a good record to come to the findings and see if you agree with those findings. And after all this is done and that decision is made, usually we often have either a findings of fact or a summary of the final decision. And then that way we present that to the board, as Chris just noted, because we do need to give that directly within 14 days so that they have an opportunity to call a hearing if needed or requested. So the mandatory conditions. So these are the state statute that outlines this criteria for variances. Our county regulations follow those statutes. There are 5 basic criteria to be considered for a variance approval, and we outline those in the report. So example, and I'll go through one by one and these in separate slides, but the variance arises from a condition that's unique and not self-created. So usually something it's unique to that particular zoning district. It's not typically found in other lots that are the same kind of case. And it's not an owner-created situation. We'll talk about those examples. The variance will not negatively affect the rights of others, so it should not have an adverse effect on neighboring properties. The strict applications of the zoning regulations constitute an unnecessary hardship. Sometimes you may recall we've had cases where there's maybe there was a problem with the structure that may have been existing, and that was in existence prior to the adoption of the regulations. That would be a hardship to the owner. The variance will not affect the health, safety, and morals, general welfare. That goes to the general police powers and our regulations, zoning regulations, the intent of that. And the variance will not be opposed to the spirit and intent of the zoning regulations. So it shouldn't be something that is totally unusual for that zoning district and something that would not otherwise be allowed. So those are just the general criteria. So I'll go through each one as an example. So unique property conditions. This is usually something that's not found in the same zoning district. It's usually a case where, again, it's unique to this property. It's not something that you would find on every single property and would become the rule and not the exception. So this is definitely something that should be very unique to that particular zoning classification. Again, like a setback situation, it would be probably there's not any others like this. There was, for some reason, there's a unique situation, and I'll talk about an example of this in a minute. So size is one of the considerations. These are all the dimensional standards, the size of a property or the area. Configuration, sometimes there are often lots that have a very unique configuration or a irregular shape. And a lot of these go back to when it was either platted that way, or it could have been pre-existing, and the property, as often as the case in the unincorporated area, it's not platted. It's just the way the property was deeded and created. It's very unusual. And so that may be cause for why a variance may be needed. The topography, we'll talk a little bit about this too. There's examples for if a very steep topography, if a owner cannot construct a building where they would normally otherwise be allowed to. Flood plans often factor into this. We have a very good justification usually when a property is within or adjacent to a floodplain. That may affect where a building location may be, therefore they need a variance. We have had some of those examples. So the next unique consideration is it's not created by actions of the owner. So this is not something that should just be created and the owner went out and they created it and then come back and ask for forgiveness after the fact. We have had those cases, if you recall recently, as well, this is something we had to do because this is where we needed to build it. That just because you did that definitely is not a justification for it. And it usually should not be created by the owner. It's usually because of the conditions of the property or other situations that may arise. So again, we'll talk about some examples of that. And may include when property is purchased with knowledge of the conditions. So if a property has changed ownership and there is a condition, a situation where it is required a variance, just because there's been a change in owner may not necessarily mean that it is would justify a variance. It is very case specific, so we would have to get into that and describe the details of that. But that's one factor to be considered for a variance. No adverse effect. Yes.
I've always struggled with this unique, non-unique. What exactly it means in this context. And without talking about any specific case, I remember we had a church that had a height.
Yes.
And I struggled with that because that church, was too high. But there's certainly other churches out there that have a higher than. And again, I struggled with, okay, does unique mean this is literally the only such example of this?
Yeah. It's a hard thing to define in every.
Lawyer and looking at this.
Yeah.
Would you ever have?
Yeah, that was one that staff struggled with that as well. And at the end of the day, if I recall, those kind of conditions, we determined it was unique because it was unique to the use. And so it had changed uses, if you recall. So that church had been vacant for years and they changed use to, the new owner created a personal workshop. So it was an accessory building, which was unique. And that was a permitted use. So that's why it wasn't a use variance. But I do remember that discussion about the height and why that was considered unique. It was, again, there's no other examples of it like that. And I don't think we thought that would create a precedent in terms of that height issue because we didn't and I remember you had a good question about the other examples of other churches and had there been any other height variances needed, and we couldn't recall any.
Right.
Yeah.
And the thing I was struggling with is, okay, we got this one here in front of us. Changing use, can be a workshop or whatever. Certainly other churches down the road that you could run into a height issue.
Yeah.
So to me, again, it was a challenge to.
Yeah.
How do we interpret?
Yeah.
Truly like the one and only.
Yeah. Yeah. You know, we,
I don't know, because I
It's-
tried to find some case law. Really.
yeah. Yeah, that was a tough one. I remember too as staff, and I don't remember at the time, if Ryan, if you remember that one. Yeah, it is a hard thing to come up with the analysis for that because there really was no other examples and we couldn't find any other examples to refer to. But yeah, if you have some thoughts on that, yeah.
I'm curious if you know of any case law interpreting that.
I don't recall. Unfortunately, I didn't really prep for this question. So I'm just going to kind of go off of memory here. I think one of the things that we considered unique about it was because it was changing use, and wasn't it? We had revised our regulations, right, to allow for accessory use buildings without a residence on the property. Is that correct?
Yeah, that was a permit. It was a permitted use. Yeah.
And so, but the accessory use building without the residence, that was a relatively new change under our regs. Is that correct? Or at least it predated the establishment of the church, because the church itself, when it was being used as a church, was allowed to have that steeple as high as it was, right? So I think what we thought was, because the church was in place, we had our new regulation come in that then that allowed to have accessory use buildings without a residence attached. And then so we had this new owner come in, purchase the property, or maybe he's in the process of it, I don't recall. And we felt that because the structure predated that reg, and that was basically what kind of helped make it unique. I believe that was the analysis that we went over. Does that match up with your memory? So again, I'm going off of memory here, so I apologize if I'm not quite on target. But I believe that was generally part of our analysis. It was basically the building pre-existed the reg that was being applied to it, and then because it was being used for that relatively new usage, that pre-existing condition is what made it unique to that particular accessory building.
Yeah, I think that helps. And thanks, Ryan. Yeah, that's why we provide that staff analysis, because sometimes and the board doesn't necessarily have to agree with that, right? And I think there can always be a dissension on that, in terms of the final recommendation. And that's fine, because some of these are not black and white, and it's not exactly the case by case thing. And there's other factors to consider, right? But that was one I recall struggling. That's a good question. It is sometimes tough for staff too to come up with that analysis. But Chris, you have thoughts on that too?
So, Chris Grunwald, legal. And so to Tim's question, I think the focus is on property rather than the needs of the applicant. Like, that's about the only guidance that I would see comes clearly through the case law. It is very tricky because you're trying to line up exactly what's causing the applicant to show up. But I think mostly you're focusing on the property there for that uniqueness situation. It may be a combination of how the property is combining with the structure, the history of the other things. But I would say focusing more on the property is probably where it's going to be most helpful.
And where I struggled with it is, certainly foresee other instances where other churches down the road might be, again, have that height and come in with a similar request. And that's what I.
Yeah. And Sean Penley, planning staff, I'll come back around to another reason why I think how we arrived at that decision on that example. When there's height issues, that did change owners, it did change uses. There was, because the fact that the reason why we even brought it, we told the owner they had to get a variance in that case was that it was existing, they were repurposing it. they had no other remedy to get it permitted other than a variance because it didn't meet the use that they were using it for, didn't meet the regulations. Not that that's always the reason why it can be granted a variance, but that was how we arrived. That was the only option they had. And it was truly unique in the fact that that's a case where there was no other situation like that we were aware of. But yeah, it's a tough one. As Chris said, we really do stick to the facts of that particular property and that particular structure and the variance that's requested. And in that case was a height variance. And each one of these is definitely different as case by case. But yeah, good question though. That can be a tough thing to argue, and it can go either way. Next criteria, no adverse effect. Of course, there should be no negative impacts as a result of approving this, or reasons to recommend approval of a variance. There should be no adverse effects on the rights of the adjoining property owners or neighbors. That can be usually pretty clear cut. Usually you see if there's going to be a potential impact. One of the things that we have looked at, and as an example here, usually, like I say, most of these cases are setback or height variances. And then, you don't want to have any kind of a negative effect on your neighbors. Oftentimes it's a setback variance. And if you recall, we had one recently that was a front and rear setback situation where they're requesting an exception or a variance for both front and rear setbacks. Usually those are easier to arrive at a recommendation of approval because you're closer to a street or you're closer to your rear property line. Usually it doesn't have as much of an impact as, say, a side yard. Side yards are probably harder usually to recommend approval because you may be closer to a neighbor. It could be blocking views or potentially restricting where, just the owners, they should not have that kind of a issue with a closer structure. That's an example of a case that might be different, but again, whatever the use is or whatever the variance is, should not have a negative impact. And so we go through that analysis again to show how we would only recommend approval if it didn't have a negative effect. And if it does have a negative effect, as you had recalled, we had another one recently, but we recommended denial. It did have negative effects on neighbors because it blocked access, it blocked visibility, and it would have definitely set a precedent for those cases. So that's what we would look at. Again, continue on with no adverse effect. The variance, it should not affect the public health, safety, morals, and order, and general welfare of the community. And that's, again, the general requirements of zoning regulations. It should not negatively affect any of those principles of our regulations. Unnecessary hardship. So this is something is definitely one of the criteria we look at very carefully. The strict application of the regulations would constitute an unnecessary hardship. And a hardship, what an owner may claim as a hardship may often go to economic impact, right? It's this is going to be this would be kind of a detrimental effect on my property. I can't use it if I can't do what I'm doing. Mere economic advantage or disadvantage does not constitute a hardship, right? We're not looking at that. We're looking at the hardship to the owner because maybe there is no other reasonable remedy. They have no other option but a variance if it is needed, and there's no other, they've exhausted all their other options, and that's something that we would look at as part of this analysis. Personal hardships is not necessarily included, and just matter of convenience, of course. So I think Chris included some good language here about the unnecessary hardship and how we define that, taking into consideration all the relevant factors and show how it's unique and cannot be put to a non-conforming use because of limitations imposed on the property by reason of a classification in a specific zone. So hopefully that helps explain that hardship language a little bit better. Consistency with zoning intent. So again, most of the variances that we have would be something that is a request for an exception to a dimensional or an area requirement. It should not be a use variance. So I think Chris gave the examples of somebody wanted to, develop a brickyard or some kind of a, manufacturing facility in an area that's rural. We often get that request. Surprisingly, we get a lot of contractors in the county, and there might be I want to be able to have a contractor yard, and if it's not allowed by right, can't I just get a variance for that? No, there are other proper methods or procedures to go through. rezoning or a conditional use permit is usually the correct options for those. So that would be the proper use following zoning. These variances should not be opposed to the spirit and intent of the zoning regulations. They're usually a very specific type of variance for a dimensional requirement, not land use, and it will not create a conflict with our zoning district regulations. And finally, just to go through a kind of a summary here of the different types of variances and our notes. As Chris mentioned, BZA may hold the hearing to authorize the variance. Only area variances should be authorized, not use variances. There's 5 conditions that are mandatory to be considered and approved before authorizing a variance. And the BZA decision must be approved by the BOCC to become effective. And just by not calling for a hearing and no action within 14 days upon receiving the BZA decision does become effective. And the conditions that we consider in variances are unique and not self-created, will not affect the rights of others, and strict applications of the zoning regulations would constitute an unnecessary hardship and will not affect the health, safety, and welfare of the community and not be opposed to the spirit and intent of the zoning regulations. So that's kind of just a quick summary of everything. I'll turn it back over to Chris for the remainder of the presentation and going through procedures.
Sean, before you leave, AJ Lang, we had one particular case where it does not follow any of these. And that was I don't want to call it a racetrack, but it was a test track. And that took, where does that fall within this?
Yeah, so we talked a bit at the very beginning about administrative decision. It turns out that was processed as an appeal of administrative decision, although you could argue that there was not an administrative decision. What that was really, it was as an example, it was a group of property owners who were appealing staff's interpretation of a requirement. In that case, that is the option for appeal of administrative decision. That's how we went through that process to the BZA. There could be a case where usually it's the property owner, right? It's usually the property owner who's appealing the decision. But in this case, it was neighboring property owners who were appealing a decision of how we were interpreting the regulations. And really it was an example. They were saying, well, they weren't following the regulations that were adopted by the board.
Right.
Therefore, we want to appeal it. So we went through that process, but that's the other option, right? Usually most of these you're going to always see as variances, but you might see an occasional administrative appeal. And that was that process we went through.
It was a very unusual
Case. And it was a lengthy process and there was outside counsel involved and it was very difficult. So Chris might be able to speak to any more questions on that and maybe provide a little bit more direction, but those are even trickier, I know, administrative appeals.
Chris Grunwald, legal. To pick up on what Sean was saying, I think that was a great question and a good setup by Sean. I would say that when there are either property owners or neighboring property owners who feel that they are, the legal term is aggrieved, but they feel that a decision has been made by the county, in this case, that they believe should be overturned. There is always an avenue to get into court. And what I would say is probably from a little bit of talking with Ryan and Sean, just in mentioning that one situation, I think there are times, especially if there's outside counsel involved and there is an expectation that they will want a court to rule, there may be a path to simply take the step to challenge where the county position is administratively and take it directly to district court. I will say it's not clear that every single disagreement with planning staff should always go through the Board of Zoning Appeals. And I would say that staff is interested in working with the party that is upset about it to make the most efficient process, because if it's going to need court review and it's headed that direction, it might actually make less sense to take it as a awkwardly packaged administrative appeal to the Board of Zoning Appeals, where it's not kind of in your bread and butter. Then it might make more sense for them to say you're allowed under another provision of the Code of Civil Procedure to take that, challenge the county's decision in district court and just begin there. Again, it's a bit of the administrative appeal language in the zoning regulations is very broad. It has that opportunity, but I do think staff is interested in making sure the right things end up in front of you. for what it's worth. And so I have two more slides and between you and the end, and any other questions you have. This one is specific to you guys in terms of Board of Zoning Appeals, which is there are times when it may make sense for the Board of Zoning Appeals to have its own legal counsel because you're sitting in a quasi-judicial role, you're making a decision, and there are times, and there are a few listed here, I'll pick up actually on bullet points 2 and 3 first. You know, there are times that are high stakes decisions from a property owner's perspective, and they may be investing a lot into the proceeding here, and it may be very complicated legally as well as factually. And in those situations where there's going to be a pretty involved hearing, it may make sense for staff to obtain outside counsel to serve as the procedural advisor to the board to help you sort through that process, have an organized and well-run hearing, but also allow you to consult with that attorney when you're having to make your deliberate on your decision and package up a written decision. Now, many typical variances come in with a staff package staff report. Many are recommended for approval, but not all. And there are recommended staff will prepare draft findings of fact and conclusions. Those will be needed at the end of every Board of Zoning Appeals decision, but you can imagine some complicated situations where it may be so involved that some additional drafting help for the board, where they might be taking a different path from staff. And again, that can be used, is extremely rare, but I did want to flag it as a chance that may come up in the future if there's a very involved case in front of the board, and staff is absolutely going to help the board and make sure you've got the assistance you need to make a formal decision that can go on for further review if needed. I mentioned that I said there were the bullet points up there. Number one, it is possible, though rare, that the Board of Zoning Appeals may rule in favor of the property owner and the staff believes that decision should get further review. That would be a case where the county staff is on the other side of the decision from the Board of Zoning Appeals and asking a district court to review it. It is extremely rare, but it has happened. There's a reported case out there, City of Olathe, as a matter of fact. So I just wanted to again flag these are what I called procedural sticky wickets. I can't explain cricket to you, but these are the goofy situations. And they do come up from time to time, and we just figured it was better to flag them for you. And again, there may be a very rare occasion where staff is seeking a review in that situation. Absolutely, the board would have its own attorney just to represent the board. You sit in an official capacity. You're volunteers. This is not put you personally at risk. If your decisions are challenged, this is a general comment I'm making here about court challenges to the Board of Zoning Appeals decisions. It's never a personal involvement for you. You're always defended by the county. They're either paying for legal representation or county legal is representing you. You have no personal exposure whatsoever. It's simply your official position that was being challenged. Any questions on that? Great. General things for boards, just a reminder for everyone. Conflicts of interest is generally, do you have a financial stake in the thing that's being decided? And that's the pretty straightforward, obvious answer. Those are direct conflicts. We do encourage you, though, to be aware. There may be situations where there's an appearance where you are involved closely with an applicant. And so bring those to staff's attention ahead of time so we can help you navigate that. There may be times when it makes more sense for you, even though it's not a financial conflict. Pretty rare, though, but just flag it for staff if something comes up. And the last 2 points there are sunshine laws, open meetings and open records. And so meetings are held in the open. And please remember all your board-related emails and texts are considered part of the public's business. So those would all be subject to the Open Records Act, even if they're on your personal email or your personal phone. For that reason, we recommend you be careful about what you put in writing. Be aware that it may be subject to an open records request. And as always, planning staff is available for, this is my pitch, I'm legal, but I'm saying call planning. But again, staff is your resource, and you have a question about something in a packet or something procedurally, reach out to staff as soon as the question hits you, and they're always happy to help. That's all I got.
Chris, I'll add one thing and we'll open up for any questions to either Chris or myself, but this is something we didn't talk about, but as a conflict of interest, we've advised other boards occasionally, you might know an applicant, not necessarily because you actually know them, but just because you might be neighbors. We have in the past recommended boards, our zoning boards especially, if they happen to be within the notice area of that 1,000-foot notice area, we do, official property owner notice, and all these applications have public hearings. If you're within that notice area, you should announce that. That's one of those things you should announce, usually at the disclosure at the beginning of the meeting. And sometimes, usually, we would advise you potentially would recuse yourself from the application. It may depend on the situation and the location, but we definitely do recommend it. If nothing else, you announce that as part of your disclosure. Do you have thoughts on that, Chris?
I'd endorse where Sean is on that. I guess I would say, the expectation when you were appointed to a board is you're sitting as a representative of the community and not as your say, neighborhood. And so sometimes we appreciate your service, and sometimes you may be put in a situation where your neighbors might disagree with your decision, or your friends and family members. So it's not something that we would reach for quickly to have you step off the board. But there may be situations where, because you're in the notice area and you're close enough and affected by it, it may make more sense for you to step off.
And that's something we always advise. We try to give a heads up. And, if you're ever you receive a notice of a variance application, it's going to come before the board, definitely contact staff to let us know about it. And it'd be something that'd be good to disclose before any application, but just always a good heads up and reminder to you if you ever do get a notice. That does not apply to other boards, though. We have had cases like that where a board member served on a BZA, let's say, and they got a zoning board notice. That wouldn't apply. That's because you're not going to be sitting in the capacity to make a recommendation on that case. That's going to go to the zoning board. But just as an example, something to think about for future reference.
So if we happen to be in that area and that person actually contacts us, we're more of a no comment, correct?
Yeah, we would always advise the board members to never have any outside contact with an applicant before a hearing. Wait till that's part of that open meetings and, that disclosure of interest and or disclosure of conflicts of interest. Definitely, it's best to not engage in any outside communication with an applicant prior to the hearing. Usually it's best to tell them your application is up for public hearing. I sit on the board, and we would advise you present your questions at the board meeting or in an email to staff before the meeting. That way it's shared with all the board members and we all consider it together at the open public hearing. And that's usually always best practices.
Chris Grunwald, Legal, and the reason really behind that is the opportunity for the decision on that case is being done in front of the whole board. So the whole board should get the opportunity to hear whatever it is intended to protect, whether it's the applicant or a neighbor, an affected property owner. The most appropriate place for that is so that everybody, on the entire board can hear it. And I think part of what Sean was referring to is sometimes there will be a statement of ex parte contact, and you can disclose for the board, I did receive, something directly to me, or somebody stopped by my house to talk about this case. I told them I wasn't going to talk about it, but we'd hear, you can disclose it. It doesn't mean you can no longer participate in it, but that's the encouragement we'd encourage. Just like I agree with you. Yeah, no comment. And also we're going to have a hearing, and that's the right place for it. And also I always recommend that you encourage any of the folks that are interested in things and reaching out to you. The sooner they contact staff, put their comments in writing, the sooner the stuff gets in front of staff and can get into the packet, the sooner they get that information, the better. And sometimes they're raising things that staff can follow up on, and the sooner they raise that for staff, the more helpful it is. All right, that gets us to the question slide.
Question. Decisions on, say, side yard setbacks, front setbacks, do those also get made in the context of, say, a replat? In other words, if you're replatting a property and you want a, side yard setback, do those variances get granted in that context as well without going through the board?
That's a good question. Sean Penley, planning staff. We get that question a lot too. Can we just get a variance for the setback reduction? The general answer is no. A variance of a setback is a variance, has to go to the BZA. However, there are cases where reductions of required setbacks may be approved by recommended by the zoning board and approved by the BOCC if it was part of a planned district or there's opportunities for other exceptions. We call them usually either a reduction or an exemption or a waiver. That's not a variance. So we usually make sure we have the terminology right. It's never a variance. So you never get a variance from a setback as part of a plat, but you may get granted a reduction of a setback if it was allowed by the regulations for a planned district. Usually they have different provisions that would allow that. Yeah, so there could be some situations where exceptions to setbacks could be approved by the zoning board and BOCC, but it's not a variance.
What are the expectations or what's allowed as far as research prior to showing up to a meeting like this? We get our packet, obviously we read the packet. Is there expectation of us doing something? Is there stuff we should not be doing? I mean, other than talking, obviously not talking to the parties involved, but as far as online research and things, is there?
I'll try to start and I'll see if Chris may have some follow-up into this. Sean Penley, the expectation of the board really is just to read the materials as presented in the packet. You're really not expected to have to do any more research, but you can do research. What we usually advise also is not necessarily going to the site and taking pictures or going, because again, that may not have been other board members may not have been able to do it, but you can visit, you can drive by and see the property. We advise usually not going out and inspecting it or going and doing any other reconnaissance, but you can certainly go see the property, see the neighborhood, just to understand the situation if you want. But you should also probably disclose that, just say you did that before an actual public hearing. And then anything else that helps you learn more about it, or certainly contact staff. If you have questions on anything before a meeting, you can absolutely contact staff. We can answer those questions. But again, usually most of it is try to wait till the hearing to do most of that. But we try to provide all the all the information in the record. So you get the staff report, the written narrative from the applicant, their analysis, their justification, any plans. We try to provide all that information in the packet, but certainly there's nothing else expected or required of the board other than what's provided to you. But if you ever have questions, let us know. I don't know, Chris, if you have any other thoughts.
Chris Grunwald, legal. I'll give you a more conservative answer from legal, which is, and it kind of gets back to, again, the decision should be made by the board, and the board should all have the benefit of what's being factored into your decision. I won't say don't do any research at all, but I would say that if you have a question that you want answered, I would pitch to you. Probably another board member might also have that same question. So I would hit staff up with what it is that you're interested in learning more about, because it could be that staff can do a supplement for the staff report. There's a particular aspect on a factor for a variance that you're not quite feeling you understand. And there might be something they could provide to the whole board and in the public packet, frankly, that all the applicant will get as well. And everybody will have the opportunity of that. So certainly if you're trying to understand the process more generally, and there's some background research that would help you feel more comfortable with it, certainly we appreciate that you're interested and willing to do it. But definitely when you're getting into the point where it's something that's peculiar to this situation and the application in front of you, we would encourage you to contact staff about that so that it's an opportunity for it to get into the record so everybody has the full picture of it. Again, a drive-by of a property can be really helpful for you, just to understand the layout, understand what it looks like. That certainly can be helpful to do. But more, and then as Sean said, more involved interaction with the property or property owner, not a good idea. But that's not really, I think, where you were.
There's just a lot of information on whether it's Google or Ames or whatever that you
Yeah.
can find pretty quickly that can
Yeah.
insight beyond this.
No, that's great. No, that's a great point too. Ames is always a good resource because they have very current aerial photos. We're pretty up to date. Our Ames department is excellent about getting regular annual aerial photos. And we try to get that up-to-date information in the packet too. So we get your up-to-date aerial photos because we're looking at the same stuff. That's always fine to do that kind of research on your own.
As far as contacting planning, is that just going back to Elizabeth or is there something different we should
You
be?
can contact any of the planners. Usually I would say recommend probably contact myself and then we could always direct to the appropriate staff. And as Chris said too, we usually what we'll try to do is if we get that question, if we have time, if it was maybe before the packet went out, we could include an update in the report. If it was already, packet did go out, what we usually will do, we'll give an update at the meeting when we do our staff presentation. Hey, we had some questions about this. So we also wanted to add the additional supplemental information that we heard from board members, and we want to have that, share that with everyone. And we do that on the record, so it's everyone considers together. All right, well, we appreciate your attention on the training. We do have this information, so the presentation, we will save this on the BZA website. And certainly we'll, again, if you have any questions, let us know. The future meetings will notify you when we do have next meeting. If there are any applications scheduled for hearing by the board at this time, we do not have any. So I'm not sure yet when we'll have our next board meeting, but at that next board meeting, we would schedule election of officers. So stay tuned. We will update the board on when we plan to have that. So any other questions?
Any other business? Hearing none? How about adjourn?
Close.
Got a
Make a
motion?
motion to adjourn.
Motion second?
Second motion to adjourn.
All in favor, say aye. All opposed. Thank you.